Welcome into another edition of Legal Access. We get together each and every Thursday morning to give you access to different aspects of the law. Today we're going to be talking about criminal law. That envelops a lot of different things, from traffic violations, DUI, drug offenses, even stuff within the court system, whether you're talking about plea bargains, sentencing, jury duty, whatever you want to ask about. Today is the day to get those questions answered. Phone number is on your screen, 843-848-8080. Call us here today and we'll get those questions answered for you. On the panel today to answer those questions for you, first of all, 15th Circuit Solicitor Jimmy Richardson.
Hey, Dave. Great.
Also want to welcome Chris Helms here.
Thank you for having me.
And on the end of the table, Kirk Truslow.
Yep, good to be here, Dave.
Chris and Kirk from the defense side, and obviously from the prosecutorial side is the Solicitor Jimmy Richardson here. And Jimmy, a lot of people will say, you know, all the money in law to be had is obviously on the defense side. What is it about the prosecution that has kept you there for so long and not really making the huge bucks that these guys are making?
Please.
And that is true. There's a lot more money to be made. I'll tell you, one of the disadvantages, and I did criminal defense for just a small amount of time, they've got problems. I mean, they work very hard. Kurt and Chris, I've known them for decades. But one of the things that these guys have to do in addition to the courtroom stuff is they're running a business too.
Right.
And if anybody can't figure out an easier way to make a living, they haven't tried hard enough, because I do respect what they do. They do an awful lot of work, and that's just the criminal side. Now, if you think about it, from the prosecutor standpoint, we're actually building a wall. We're building a case against a person. And to me, this part's a little bit easier. But all Kurt or Chris have to do is mess up the integrity of that wall in front of a jury. They've got to remove a brick, or they've got to, push into it. So I do think that our side is a little bit tougher on that aspect. But when you take into having to bill, having to collect, having to hit all of those meetings, my check is going to come the same amount. It might be smaller, but it's going to come every other week, and I don't have to go beat the bushes to get it in.
I think I saw that brick argument on My Cousin Vinny, if I'm not mistaken. So.
Probably.
Well, speaking of prosecution versus defense, what's easier, finding one person to disagree with the prosecution or finding 12 people to agree?
I think it's, I've had a lot of hung juries and mistrials. And, if you have 12 people, you've got 12 different people looking at it. And I've found it, I won't say easy by any stretch of imagination, but to get one or two people, if they can hold on and mount the pressure that's on them, but from the other folks when they're deliberating, that can happen, yeah.
Yeah, I have to agree with Kurt. I've worked for this guy for the better part of a decade, and I've been across the table from him as a prosecutor and a defense attorney, and there is something to be said about not having the burden of proof. If I go to court, I don't have to prove anything. This guy and his folks do, and they're very good at it. But to piggyback off what Jimmy said, it's a lot easier to knock a house down than it is to build one. You don't have to know anything about construction to knock a house down, but you got to know everything to build it.
It really is, and Dave, a part built into the criminal law is this idea, and people give me this all the time about why, if the police made an arrest, why isn't that enough? And the easiest example I can give our viewers is if you'll think about a seesaw out on a playground. The police need to tilt that seesaw. One's a little bit heavier than the other. And that's all it takes to get arrested, 51% to 49%. More likely than not that a crime was committed, and committed by Dave. But then they pass that file over to Jimmy, and now I've got to prove to 12 different individuals beyond a reasonable doubt. And the way I describe that is, instead of 51 to 49, that's 85 to 15. And so there's a lot of times that the police did the right thing. They made an arrest, the bad person, the bad act is stopped off the road. But that answers that question, why there's a lot of difference between 85% or maybe 90% and 51%. And that's that level that we've got to make sure, and we've got to do it 12 times over to each individual. So the question of having a hung jury, Kurt won't ever remember this. He got a bad memory. But 20 years ago, at least 20, me and him were it was over 20 years ago, it was the old courthouse. And Kurt had a defendant that had a DUI second offense. And I was trying to get Kurt to let us send that back to magistrate's court as a first offense, which is smaller. And one of the judges was really jumping me really bad. I'm not going to try a DUI. I'm not going to hear that case. And you should send it down to magistrate's court. And I turned it, I said, Kurt won't send it. But Kurt knew that I've got to hang up one of 12 here.
Right.
And in magistrate's court, I only got 6
Good conquer.
to hang up. So she twisted his arm. It ended up going down, but it was, that kind of explains it. You got 12 people that you've got to convince beyond a reasonable doubt. And it happens a lot of times. The police did everything right, but there's just no way to make up that ground.
I do remember that, and judges do have a way to twist your arm.
They
Oh,
did.
yeah,
They want you to do something.
For sure.
I would pull that stuff in school, everywhere else. You just got to get them off of you and onto somebody else. I was like, it's Kurt. It ain't me. It's not me, Judge.
Speaking of DUIs, I know that the state legislature here in South Carolina has passed some new laws as far as insurance and DUI is concerned. Are there any new rules in Columbia that you guys are aware of that are being discussed as far as the DUIs or any other laws that you guys would be taking care of?
Jimmy would know more about this than I would, but there's certainly an effort to strengthen the DUI laws in South Carolina. You know, statistically, we don't fare well against the other 49 states. And I'm saying this as a defense attorney. The truth is that the DUI laws are strictly written, and they're tough to comply with sometimes from a law enforcement perspective. You know, DUIs in this state have to be on camera, not just video, but audio recorded too. And if they're not, that's something that Kurt and I are we're gonna attack it. And I think that is a real focus for the legislature. But Jimmy, you can speak more to that than I could.
So I went and testified to House Judiciary maybe 2 weeks ago. And they're trying to pass, like Chris said, some laws that they say to strengthen it. Nobody is safe while the legislators are in session. So it's going to make it weaker. But I was testifying to that. And Dave, in a murder case, by statute, they say prove that the killing of another with malice aforethought. 4 elements. In DUI, it's 26 pages. All of it's loopholes. In North Carolina and some other states, Tennessee especially, it's pretty much prove the DUI any way you want to. And they don't have 26 pages of rigmarole to go through. But ours is built that way, and it is very tough. But right now it's in committee, and you know, if they do pass it the way it is, it'll make it much easier for defense attorneys to be able to defend those cases.
Right.
If it passes the way the Senate sent it out, it'll be slightly easier on prosecutors. But the House has added some stuff in there, and blood draws and all of that's going to make it all but impossible.
Does that have to do with the fact that the majority of our legislators are lawyers?
That guy right there is hosting a show. That is exact. And see, legislators never want, even though they're defense attorneys, a lot of them, they never want to turn loose a murderer or a burglar or a rapist. But they make a lot of money on DUIs. And it is a misdemeanor, and that's why it's 26 pages long.
Tell you what, we're going to run to a break here real quick. When we get back, we would love to answer your questions about anything the criminal law oriented, whether it's traffic, DUI, drugs, or the court system as a whole, please feel free to give us a call. We'll get you on the air right here on Legal Access, brought to you by the McGuire Law Firm. Welcome back. It's Legal Access. We're talking about criminal law here today. The phone lines are open, 843-848-8080. If you have any questions you would love to have answered, today's the day to get those answered on criminal law. And in my haste, the last segment, to get to the actual topic, I forgot to introduce all of our guests here on the panel. Chris Helms, one of our defense attorneys here. Your firm, where's your firm located? What's the name, and what else do you work with besides criminal defense?
I'm with Inlet Law. The long name is Joy, Napier, Risher, and Hardin, but we DBA Inlet Law. We're down in Murrells Inlet beside the apothecary, right across from the Inlet Crab House. And we do a little bit of everything. I think the only thing we don't do is family law, but we do a little bit of everything there.
So where you're located, you have a lot of good lunch choices, I imagine.
Yeah.
Look at me, Dave. I'm never hungry, man.
He ain't lying. He's big. He was small when he was with our office.
That's true. It's true.
It's because he's making all the defense money, eating well.
Yes.
Yeah.
It's getting spent.
And Kirk Truslow, your firm, and what else do you work with besides criminal
Yeah,
defense?
just criminal defense work here in Myrtle Beach off of 44th Avenue and Grissom Parkway.
Now, we were talking about DUIs going into the break a couple of minutes ago, and DUIs, obviously, since we live here in a resort community that, pretty prevalent, that we see down here, people come and party around a lot. Now, we have been working, I know that about 5-6 years ago that the state was getting on this circuit to try to clear up their DUI backlog because it had gotten pretty big, but now it's down to a manageable place. Now, there are things that you can do if you've had a DUI arrest. We talked about PTI, pretrial intervention, and also the treatment court that you guys instituted in the solicitor's office a few years back. How has that helped to get the backlog of DUI arrests down?
Well, treatment court is, they will not allow you to put a DUI into pretrial intervention. But treatment court is a post plea. In other words, you plead guilty to the DUI, but then if you can go through this 6-month, 9-month class where you're drug testing and alcohol testing and all of that, and counseling, at the end of that, they can open up your record and do away with the DUI. It's all by circuit court. Now, if you fell out during the term, you go pull whatever the underlying sentence was. But most people, Dave, whether it's drugs or, well, alcohol is a drug, but a lot of people really have problems with it and just don't have the manner and mechanisms to be able to do it on their own.
Right.
And it has been I'll give you, not necessarily on DUIs, but we did a study on the first 500 people that went through. It's been around for 20 years now, but the first 500 people that went through our treatment courts, they averaged at the time 11 arrests apiece. So in Ainer math, that's 5,500. And I say that because I'm from Ainer. But upon graduating, that same 500 people were responsible for 100 arrests, and 40 of those were misdemeanors. So you go from 5,500 to just 60 felony arrest. So it is making a huge, huge difference. And the fact that 11 arrests apiece, these are people that were not just beginners. These are people that,
Right.
Had been had a significant drug problem or alcohol problem. And it takes a minute. So I say this to parents, to loved ones that are trying to send their loved ones to different, like Hebron, and there's some great places out there, Christian-based. There's non-Christian-based. There's some good programs out there. But anything that's like 60 days, 90 days, you're probably, that is not, in my opinion, that is not enough time to break a terrible habit that has gotten you arrested 11 times.
Yeah.
And it maybe takes a year and a half or 2 years, but it's a lot more intense. The drug court, treatment court is a lot more intense. But you didn't just get here overnight. And I may be wrong, I'll leave it to y'all, but if y'all think differently, I'm certainly not the guru on that.
No, I'm a big proponent of treatment court. I think it, and I was as a prosecutor and as a defense attorney. The catch is this: there's carrot and stick. You have already been to court, you've already accepted responsibility for what you're accused of, and you are already sentenced. That sentence is just kind of held out there until you complete this program, and you either do it or you don't. There's no middle ground there. It's pretty black and white. You either do it or you don't. If you do it, then it's like it never happened. It's the closest thing to a get out of jail free card there really is. But if you don't do it, I don't get to talk about it anymore. You just go to jail or serve your sentence.
Yeah, there's no subsequent hearings. It's just you just report to prison. That's it. But I too have had some clients who I never thought would get clean and sober through treatment court.
Yeah, I want to kick in one more thing because Kurt reminded me. We fully understand that if a person comes into treatment court and has been arrested 11 times, they've got a problem. So we don't kick you out for failing a drug test or alcohol test. But the punishment is immediate, and it is going to jail, and it may be for a day, it may be for 2 days, but we don't impose the whole sentence. We send you to correct that behavior, and then we pull you out and we start back over. And we go back through the counseling and we do everything again. And we expect people to fail multiple times, but it is only when people really abscond and say, I'm through with it.
Yeah.
I know both of these have, because we've talked about it, but people that had gone into drug court and say, this is too big of a burden, I'd rather just plead guilty and take my time. But we're going to have to arrest you again. There's no reason for you to pay a fine. Let's go ahead and fix it while we're fixing it.
We're going to run to a break here real quick. When we get back, we would love to talk to you. If you have any questions about criminal law, whether it's drugs, DUI, traffic offenses, or the court system as a whole, please feel free to give us a call. Phone number's on your screen. We'll be right back here in a couple of minutes on Legal Access, brought to you by the McGuire Law Firm. Criminal law, that's our topic here today on Legal Access, brought to you by the McGuire Law Firm. Please feel free to give us a call. The number's on your screen if you have any questions about criminal law. On the panel here today to answer those questions, Solicitor Jimmy Richardson, also defense attorneys Chris Helms, and also Kirk Truslow. I'm Dave Priest, but that's not important now. Just give us a call. We'll get those questions answered. Let's talk about court for a minute here. Court itself, we see a lot of TV shows and movies that, say, this is what happens in court. How big is the quote-unquote CSI effect that juries these days expect to have DNA evidence, CCTV, and everything?
Not as big as I'd like it to be, but bigger than he wants it to be.
Yeah, good answer.
Yeah, they're right. It's you, and I have to constantly stay on our people that if you are just banging away at these elements and you don't allow the jury to be invested and to understand the motive. We don't have to prove motive, but you better, because the CSI effect is there. And Kurt and Chris do an excellent job of saying, you don't have any DNA, you don't have any videotape. Yeah, that's true, but a lot of times people don't rape or pillage on camera. Now they may leave DNA at sometimes, but that's like a year and a half, 2 year backlog, because we have to send that to SLED. I can't test it. There's no back computer like I always sort of thought. And on the TV shows, you put it in there and it comes back and tells you, yeah, that's Chris. You have to send it to Columbia and it's got to be packaged a certain way. and we got to make sure that everybody touches it, signs up for it, the chain of custody, and then they come back and tell you if it's that person or not that person. But jurors do want to see that.
And more cases these days involve stuff like that. Telephones, video surveillance, everything's on video. You know, we were on video probably walking into this building and didn't know it.
Probably.
But everything's generally on video. But it's important to keep this in mind too. People committed and were prosecuted and convicted for crimes long before DNA evidence, video surveillance, things like that. So it is possible to be convicted and your case doesn't have fingerprints, your case doesn't have DNA, your case doesn't have a confession. Every case is different. And I'll be honest with you, and Kirk's the same way, I'm sure. There's never been a case I couldn't find something wrong with, but is it bad enough that negates your culpability? That's the question, you know what I mean? And not that we have to prove anything, but I think it's important from a defense perspective. Don't get too hung up on what they don't have. Let's look at what they do have too.
Yeah, no doubt about it. No doubt. I think a prosecutor who touches on motive, like Jimmy said, and hammers elements, is going to get away with not having DNA and video, and you know, you need to know that going in and not rest all your laurels on that, for sure.
Okay, so you guys have a case in front of you, and you've got your case all kind of worked out in your head. All right, I want to go from here to here to here to here, and then you get in front of the jury and in court, and the case that you're laying out, it looks like it's landing like a Led Zeppelin because you know, you look at the jury and they're just not paying attention. What do? Do you just make a 180 at that point in time, or do you keep hammering along how you have?
You got to be able to switch gears, no question about it. I've had trials before where I went in thinking one thing and then wound up saying the exact opposite. You know, trying the exact opposite theory based on what came out and the way it came out.
Or from a defense side, do you kind of look up there and you find one person that's really, really paying attention to you and nodding their head and stuff like that? You concentrate on them to try to get
That's
them
my
on
best
your-
friend. If he's nodding, he or she is my best friend after that. Absolutely.
I think that's also the first time I've said Led Zeppelin on this show, just
Yeah.
short. All right, as far as being in court is concerned, I know that a lot of times that we'll come up with a sentence, and it's up to the judge to determine what the sentence is. Usually there's sentencing guidelines. What impact does impact statements have on what the judge decides on what the actual sentence is going to be?
From a prosecutor's role, it's critical, and I talk on this every day, and I think even police may tell victims, you know, give me your statement and you don't have to come back and we'll handle it. And that is not true. If you're saying that a rape occurred or a beating occurred, that jury expects to hear from the victim, and the judge expects to hear from them. Now, if it's going to be a plea, and there's 100 reasons, Dave, that a victim would say, I don't want to relive this, and I get it.
Right.
And if it's going to be a plea, we'll read a statement or whatever, but the judge really wants to see the victim there. And I've seen sentences go down or when they don't show up, and I've seen them go up when they do show up.
Also, one last thing as far as courts are concerned, we only got about a minute left. Short deliberations, long deliberations. Does that aid the defense or the prosecution?
I don't know.
I never know, because I've seen it go both ways.
Yep.
Yeah.
Yeah.
It'll give both of us heart attacks.
Yeah.
Sitting back there, Lord, what could I have done better?
Yeah, and I've won cases I thought I should lose and lost cases I thought I should win. So the length of time, I don't know if it had any correlation to my success or failure.
And on the TV show, there's always a bar right around the corner from the courthouse where everybody goes and hangs out and wait for the verdict to come in. So yeah, I don't know if there's a lot of bars in downtown Conway or not, but all right, tell you what, we got to run here right now. Next week when we get back together, personal injury is going to be our topic. If you have any questions about that, hang on until next Thursday at 11 o'clock or 11:30, and we'll get you on the air and answer those questions. I want to thank our panelists here, Solicitor Jimmy Richardson, also Chris Helms, Kirk Truslow. Thanks for being here today. We'll see you again very soon. Thanks for watching Legal Access. See you next Thursday right here on WMBF News.
You may wish to consult a lawyer to obtain case-specific legal advice. Information regarding lawyers can be located online or by contacting the South Carolina Bar Lawyer Referral Service, toll-free at 1-800-868-2284. If you are currently represented